We gather here on this rather dreary evening to talk about something rather niche but definitive in the field of arbitration, which is whether curial courts have the power to modify arbitral awards at the enforcement stage in a Section 34 proceeding. Really, this idea of having a panel discussion sprung from an elective course at the National Law School on the practice and procedure of institutional arbitration, which was co-taught incidentally by two of our panelists here, Pramod sir and Vikas sir. And I was attending that. And I remember having this very debate in the initial classes that we had in the course, but this was obviously before Gayatri Balasamy came out. And the overwhelming opinion in the class that it is obvious that the courts do not have the power to modify, and therefore it was rather surprising to all of us when Gayatri Balasamy 4-1 decided otherwise, and we then thought whether it's actually that obvious or not, which is the rationale of having such a panel discussion to really get to the root of the matter and to talk about it normatively now, because we know factually now that the courts have the power to modify per the majority. So it's really a philosophical and a normative question whether they should have the power to modify, which is the reason we've convened here today. So I'll just give you a brief introduction of the panelists because our moderator, Dr. Apoorvi, will speak at length about the background of the judgment anyway, so I won't sort of speak about that now. So Senior Advocate Pramod Nair, he's named as a leading arbitration practitioner by Global Arbitration Review, ranked in the list of top 45 global practitioners of arbitration under the age of 45. By Who's Who Legal, I mean, back then, right? Advocate Nair has also been recognized as India's top 100 lawyers by IBLJ. He's conducted arbitrations in various jurisdictions in Europe and Asia, and under various institutional rules such as ICC, LCIA, HKIAC, SIAC, and ICSID. Sir has also the distinction of having represented the Republic of India in arbitrations commenced under bilateral investment treaties and has also represented India at the United Nations. Now we move on to Mr. Vikas Mahendra, who is a partner of arbitration at Keystone Partners and a specialist arbitration practitioner at that. His illustrious practice in arbitration includes handling investment and commercial arbitrations, both institutional and ad hoc, in India and in other jurisdictions such as Southeast Asia, Central America, Africa, Europe, and the UK. Before joining Keystone, he worked for over 6 years at Herbert Smith Freehills, London, at their Paris, London, Singapore offices. He's also empaneled with HKIAC and SIAC, and has also assisted the high-level government committee to review institutionalization of arbitration in India, and currently also has the distinction of serving as the Joint Secretary of the Arbitration Bar of India. We also have the honor of being joined by Mr. Anind Thomas, who brings a unique blend of expertise in dispute resolution and niche areas of data protection and information technology. And he's a partner at AZB Partners with a wide-ranging experience in M&A, private equity, and venture capital, along with dispute resolution that we obviously. Also, I personally have had the honor of interning with sir twice at AZB, so I know he's a good boss as well. Yeah. Right. So, and then we have Professor Jaya Vasudevan, who comes with a rich experience of more than 20 years of teaching and research at various institutions, including the Indian Council of Arbitration, the FICCI, University of Delhi, Heidelberg University, Fiji International University, and she also has a PhD in International Commercial Arbitration, and has been awarded the Alexander von Humboldt Fellowship, the Institute for Foreign and International Private and Business Law, the Heidelberg University, and visiting research fellowship at the Max Planck Institute of Comparative and International Private Law. She also serves as an active member of various widely recognized professional bodies and arbitral institutions in Europe, and she has to her credit several contributions to the scholarship of dispute resolution in India, the most recent one being published by the Cambridge University Press by the name International Arbitration and India, Practice, Politics, and New Comparative Perspectives. And today we also have a moderator with us, Dr. Apoorvi Shrivastava, also a PhD, currently an associate professor at Manipal Law School, teaching experience over a decade and taught at premier institutions like HNLU and ALSAR, and an ADR enthusiast, obviously, and an accredited associate of CIRB, and a member of various other accredited bodies as well. So, can we all join to applaud our panelists and sort of kickstart this panel discussion? And I'll hand over the mic to Apoorvi. Thank you so much.
Thank you, Malar. So on behalf of the entire panel, thank you so much for the wonderful introduction. So good evening, everyone. Beautiful place and wonderful weather, I believe, to deep dive into this judgment, which has actually sent wave across the arbitration circle. That is Gayatri Balasamy versus ISG Novasoft Technologies Limited. So to quickly actually tell you about this is something where Supreme Court has actually departed from its earlier stance. So in 2021, we had Project Director NHAI versus M. Hakim, in which actually Supreme Court said that no, they really do not want to interfere into the modification of the award with regards to the compensation. While in this case, completely different scenario is here. So if you see, this particular scenario actually started in the year 2006, where it started with a very small issue. Okay, I'll just correct myself, not a small issue. It was something around sexual harassment and termination, wrongful termination. And that actually went to the court. And court referred it to the arbitration. The journey, something which started in 2006, then arbitration tribunal came up with the award. Award was not satisfactory. Then the party went to the Madras High Court, filed Section 34 application to set aside the award. Again, continued struggle where we went ahead with Section 37. Appeal was filed. Division bench of Madras High Court heard that. Again, further, they went to the Supreme Court. There was SLP filed. So during the SLP, the court realized that there is a crucial question of law involved, and it was referred to the constitutional bench. So here we are actually discussing about the constitutional bench judgment, which actually came in April 2025, very recently. So in this, if you actually see what happened, that the Supreme Court actually invoked Article 142, which is something which is very not normal in cases of arbitration per se. And by invoking that, they actually said that they can modify the arbitral award in the interest of the justice. So this particular case, of course, is cautiously welcomed because from the scenario that there has been some compensation and some clarification, but there are also a flip side where there have been a lot of questions with regard to the judicial limit and finality of the arbitration, and what is the legislative power, or do we require some sort of an amendment? So this is what we are going to look into it today. But apart from that, of course, as Malhar also requested, that there has to be something regards to the equity in the arbitration segment. So we will also look into that how arbitration can also reach to the people without the deeper pockets. Maybe some element of the legal aid, and also with regards to the third-party funding, we'll be looking forward to it. So hopefully you will enjoy this discussion. So moving on, so let's just get started. So maybe I'll start with my first question to Pramod here. Is that works? So yeah, so I wanted to actually ask here is that if you actually see in this particular scenario, the court actually tried to navigate between the conflict of limited interference, which is there in the Act, and the necessity of the complete justice by giving these 4 exceptions which we have. So do you think that is something which was necessary to kind of looking at the interest of the claimant? Because if they would have set aside completely, it would have been the detrimental thing. So is it good to ensure the fairness, or do you think it is something where we are rolling back on the minimal interference doctrine?
Could I just answer that at a more broader and more general level rather than with respect to the facts of this case itself? Just a few points. Firstly, I think when we studied constitutional law, Article 142 is not really in that sense a source of law itself, right? And it's not a power which in a sense supplements the constitutional article which enables the legislature to amend the constitution. Article 142 is essentially meant to mold the relief. It is not meant to create new law. But that rule has probably been observed more in its breach than its observance by the Supreme Court. So there are 2 aspects to the question. One is, can the courts modify an arbitral award? And the second question is, should it? if the answer to the first question is in the negative, then whatever may be the normative reasons for seeking modification, the courts should simply say that this is a matter that has to be addressed to the legislature. We can't do anything about it because the statute is very clear. Now, the way I look at it, the statute is in fact very clear. It does clarify in many ways that the courts do not have the power to modify an arbitral award. And the reason for that is clear, because when parties invest an arbitral tribunal with jurisdiction to decide disputes, the other side of it is that they are also ousting the courts of jurisdiction which they normally have, right? So these two are inherent parts of the bargain. So they have greater confidence in an arbitral tribunal. They've invested that confidence in the arbitral tribunal. It's probably a vote of no confidence in the courts. They really don't want to be in the court. That's why they choose arbitration. And the moment you start having greater judicial intervention in the arbitration process, and with this decision, I would say that arbitration becomes the first tier in a long ladder of appeals all the way to the Supreme Court. And that's not really what parties intended. That's not the scheme of the Act. I quite see the wisdom of the courts saying that we must have the power to tinker with arbitral awards, because in cases like this, when there is probably a small error, it makes sense for the courts to, in a sense, correct that error by itself rather than remanding the matter back to an arbitral tribunal. Because if you set aside an arbitral award and the parties are then required to commence an arbitration de novo, that will take many months, if not years. There is also an added expense. And whatever that arbitral tribunal decides may also not be final, because that award can again be challenged before the courts, etc. And there will be this never-ending saga. So I can understand the wisdom of the courts deciding the way they did, but is that permissible under the scope of the Act? I would think not.
Okay, thank you. So here I would just like to have a follow-up question with you, Anind. So as pointed it out that, under Section 34, there's not a very specific provision around that, but there's nothing like that in a mere plain reading. But court in this case actually pointed it out that they do have power hidden under Section 34 where they can actually modify. And if you actually see, of course the bill is there, and even in that particular bill also we can find that there is a provision where there's an intent that they specifically wanted that it needs to be there. So what's your take on that?
So the bill, first off, the bill has a much wider scope for interference than what the Supreme Court has held in this matter. If you look at both the decisions, both the minority and the majority view, the majority, of course, has gone a couple of steps further, but even the minority hasn't stayed with the position that hands off, I either set it aside or I don't interfere. Even the minority has looked at it and said, yes, there's this ability to partially sever provisions of the award, which I don't find in 34. They've taken a portion of the proviso to 34 to 4, if I'm not mistaken, and which is supposed to be read in a particular circumstance, and they said, oh, that gives us the power to even partially set aside. And what's a partial setting aside? It's a modification. So all of them seem to agree that they have the power to modify. Both of them agree that yes, we have the power to make clerical changes, which again you can't find anywhere. The majority says that this is my inherent power. The minority said no, this is because the act of court should prejudice nobody. But the fact is that you find that yes, changes can be made. It is, I think, practical to have this. Yes, the provision. Everyone agrees that the statute needs to be amended. No matter what the judgment said, the statute needs to be amended one way or the other to clarify. But that said, it does not mean that today, and that's what the Supreme Court has held, and both decisions hold, that there is limited ground to interfere. The limited ground to interfere is one, when can a court interfere? And if it decides that, yes, this is a matter where court's interference is required, what is the scope of interference? Whether the scope of interference is only binary, either I don't interfere or I set it aside. Or instead of setting it aside and sending her back, for example, from 2000, she's been dealing with the matter for almost 20 years. Instead of sending you back to a fresh arbitration and asking you to restart the process from there, if the court believes that these limited circumstances for judicial intervention have been met, and then it decides, okay, instead of sending it back and restarting this entire process, I make a minor change. Even the majority has only said there are 2 or 3 places where we can interfere. It doesn't permit you to sit and do a merits-based review. The minority said there are two of these three that the majority said, except for 142 and except for post-award interest.
Yeah.
That's the only place where they vary. But both of them seem to suggest that you can intervene in appropriate cases.
Yeah. Thank you. So Vikas, if I may just ask here that, as it was pointed out again here, that interference can be in the limited scenario. But when we are talking about limited scenarios, of course, when the issues are with regards to the computation or obvious errors, do you think there is a case that never ever court will enter into the merits? Because it's highly debatable that when you go into the issues or interpretation of the contracts, you will not touch merit at all. And it's kind of defeating the purpose again of the Arbitration Act.
See, any kind of supervision by the courts will, of course, entail some degree of looking into what has happened. So you can't say that the courts need to be blind to what has happened, because then you're essentially rendering that power nugatory. There's really nothing the court's doing there. But really the question is, to what extent do you look at it? Because from a very practical level, the extent makes a difference of either, as we have today in the commercial courts, maybe potentially 2 or 3 months that you have setting aside application decided, or as you have in the context of a regular first appeal in the civil court, you have 10 to 15 years for that decision to get given. That is the distinction that we must look at, right? It is not whether the courts at a very philosophical, ideological level have the power to look into it. I think it is common ground that they will look into it. It's really the extent to which you need to look at it. When you look at modification, correction, typographical errors, by definition, they are some things which are very evident that you can demonstrate with next to no evidence. I mean, it could possibly be on the basis of the pleadings or the submissions there. I mean, if someone said 3 + 4 = 8, you need to only show them that and say that that's what the error is. That degree of oversight is statutorily recognized. And that's what the statute said, you please do. Because, we don't want a situation where even those kind of errors go unpunished. Not unpunished, but at least unsupervised. But the minute you start exceeding that mandate, and what we call in expropriation, right, it's creeping expropriation. You start slowly but surely digging into that realm. There is no stopping where that will, because India, as a federation, I mean, you look at the number of states, the number of districts, the number of commercial courts that you have. It's not like there is one court. And I think that's where the contrast with something like a Singapore or a contrast with something like an England comes in, where you have specialized commercial judges who are probably listening to a very limited number of them. And the kind of assistance they receive, the kind of training they receive before they get there, just makes the jurisprudence likely to be a little more consistent. But the minute you have, 5,000 judges across the country with varying degrees of awareness and expertise making these determinations, you can't draw that line unless the legislature says these are the hard boundaries. Then at least the court can say, okay, well, I know the legislature has asked me to stay within these bounds, let me keep it there. But the minute the Supreme Court starts saying things like it has in this decision, allowing scope for some degree of interference, it is that spectrum between 2 months and 15 years, which is starting to move further towards the 15 years, which is really the problem. I don't think I personally have a problem with the act. I mean, I have a problem, but really not as much with the substantive outcome of it. Because substantively, maybe the courts will get it right. Maybe the parties will get what is the decision that on the merits was more justified. But practically, I don't think it makes sense.
Okay. So here I just have one comment, because actually even in the court it is said that it cannot be a regular feature. I believe the comment where it is said that it cannot be a regular feature is also because, as you rightly pointed out, that we need a clarity in the legislature itself. Otherwise, maybe there could be a lot of misuse and judicial overreach. So, Dr. Jaya, here I would like to ask you that this is not like a first instance. If you actually see, there have been some previous cases also where there have been a little bit of a modification. If you talk about MS Orient versus State of Kerala or Vedanta in case of international arbitration, there have been a modification of the award where we are talking about the compensation. Do you think there is some sort of a precedent or there is some sort of a direction which will help us to understand how to move ahead, or we definitely need a proper legislative amendment now?
Uh, having said that, I believe the present case, it represents a very factually very unique situation. The claimant in this case, she had already undergone, almost endured a prolonged litigation. And then from the facts of the case, it is very clear that there was no reason for the court to set aside the award fully on the grounds which are set out in section 34, right, about clerical mistakes or about any kind of patented legality on the face of it. So what the court could have done is simply to avoid further hardships to the claimant, to see that, the basic principle of arbitration which talks about competence or severability, the same principle has been applied here. If part of the award can be distinctly separated, then separating that part of the award, which is clearly distinguishable from the rest of the award, and making it still operationable at the plaintiff level, right? Sorry, claimant's level. So that is what it has been done. But then who is competent to do that? Should that be a kind of the court's power is limited in the essence to suggest to go for a re-arbitration? Then it is not only delaying the whole process, but it's also escalating the cost and would undermine the basic core principles of arbitration, which is based in fairness, efficiency, and swift dispute resolution. So to your question, like the previous cases, of course, the NHA case where the court said no modification is allowed because arbitral award, it's the whole competence is vested with the tribunal. So whatever the modification is allowed, that is to the extent of rectifying a clerical mistake or something which is very manifest on its record. But now, again, in the Vedanta case, the court has allowed compensation to a certain extent, looking at again, the particularities of the case to prevent the misuse of the process, or what we can say, to help the parties to recognize the values, the core values in arbitration that is based in certain principles, certain doctrines of autonomy of the parties, or, the justification that is to be provided for preventing or avoid hardships to the parties. That is what exactly, because they have opted out of the common ordinary court procedures. So definitely they would want to see that they are guided by certain principles which are based on the principles of natural justice, or maybe certain procedural rights that which they would certainly demand in the course of arbitration. So that should be there. So I believe that that was the approach of the court in this case.
So I believe you feel that it was required for the complete
I choose to take a middle ground, not too extreme.
Okay. So here, I'd like to ask a question to Anind here, that it is actually said that, as Dr. Jaya said, that it was required for the complete justice. Now, one thing which I feel that we also have Section 33. So why not use Section 33 rather than talking about the complete justice? Or do you think there have been cases where patent illegality has been triggered instead of 33? Or like in this case, Article 142, an equitable call. So why do you think all these things are happening and not like 33?
See, 33 seems to be the most logical way of dealing with a clerical error. You go back, that's what you do under the CPC as well. You go back to the court that passed the order saying clerical errors, please correct. Why both decisions, the majority and the minority, felt that the Supreme Court should or court should have this inherent power to correct clerical errors, I'm not too sure, when you could have just as easily, especially when you recognize and you go on about the power of the court to remand the matter to the arbitral tribunal. So when you have the power under 33 to go approach a tribunal in the first instance, you have the power to approach court, which can then remand it back to the tribunal. Why the court needs to hold on to this power and say that I also have the power to make these changes, I'm not too sure. But the fact is that if you look at it, in the various decisions where there has been interference, the court has found various reasons why it should interfere. Either because it's a clerical error, there's no point of going, and maybe that's also one of the factors is by the time the court actually hears the matter, so long has passed that they then feel reluctant to send it and spend further time sending it back to the tribunal for further clarification, especially if it's an error that is apparent and it's only clerical. So don't send it back to the tribunal. We've taken months or years to get to this stage. We'll finish it here. Now, when it comes to then you get a question of no, my powers under 34. I have the power to, for whatever reason, look at it and possibly set it aside, but not take the nuclear option of setting it aside and sending people back. So the courts have found ways in different circumstances, in different fact situation, to interfere when it felt that it had to interfere. There are a couple of things that we need to remember. One is the circumstances in which a court should interfere, and those are limited. The 34 has been tightened and tightened. It has been amended multiple times to make sure that courts don't interfere very often. This judgment does not change that. It doesn't say that a court can interfere more often than it was earlier possible. What it does say is that if the threshold to interfere or intervene has been met, then I don't just have the power to set aside the award. I have the power to do something which is, in the words of the majority, less severe, and modify the award as opposed to completely setting it aside. And the majority itself in the decision tries to justify it as being practical and pragmatic approach.
Okay. So I would just like to ask this, Pramod, to you, that do you think that, Section 34 was definitely, in a way, we are saying, the court is also harping and the panel is also harping on the fact that, it has to be minimal interference, and 34 is not talking about it. But can you throw some light that how actually the 34 was interpreted by the court, and feeling that, no, this is the right call for the majority, and not looking into the concepts like finality of the arbitration or the party autonomy? Yeah.
I think a very simple, or maybe in some ways a simplistic reasoning. The reasoning which carried weight with the majority in the Gayatri Balasamy case was that there is no express prohibition in Section 34 for the court to modify an arbitral award. So therefore, we do have this implied or inherent right to modify, which to me is clearly wrong textually. One, because you asked a question about guardrails. And the guardrails are there in the statute. If you look at one of the most defining provisions of the Arbitration Act, it is Section 5, which is often glossed over. Now, Section 5 of the Arbitration Act says that except as expressly provided for in the Arbitration Act, no court shall intervene. Now, what does that mean? It means that unless you trace an express power to a specific provision of the Arbitration Act, there's nothing that the courts can do. So if you don't have the power to modify in Section 34, you can't. You can't say that there is no prohibition in 34 because the prohibition is there and it's traceable to Section 5. That's one. The second, the power to modify is a concomitant of an appellate court. Now, this is again some place where I think 95% of judges probably get it wrong. They think that a Section 34 application is akin to an appellate power or is an appellate power. It is not. Now, if you have a decree of a trial court, that decree of a trial court can be challenged on any question of law or fact before an appellate tribunal. And because you can't have two decisions on the same subject matter in force, there is the doctrine of merger, which means that the doctrine of the judgment of the appellate court merges into the judgment of the lower court. And that's part of the appellate process, right? Now, Section 34 is not an appeal. So these are two parallel streams, and they're never intended to meet, right? Because you have arbitration, you have litigation. Arbitration, the reason why you have these protections is one, to act as a check and balance on an abuse of authority by an arbitral tribunal, because otherwise the arbitrators are a law unto themselves. So you need these checks and balances. The second is you need to ensure that there are some provisions to ensure that there's no miscarriage of justice. That's why you have a provision like Section 34. But 34 is not an appeal. It's an application to set aside an arbitral award on very specific grounds, that there is in fact no arbitration clause, or that the subject matter of the arbitration is not arbitrable, that the composition of the arbitral tribunal is not in accordance with the agreement between the parties, or the arbitral agreement is contrary to public policy. Now, these are the limited grounds. It's not an appellate power. It's a very, very narrowly defined power to interfere with and set aside an arbitral award on very, very specific grounds. You asked a question, and I thought that was really spot on in terms of what the dangers are. Can you actually define this scope of modification? And Vikas used a correct expression, it's a slippery slope. It's a slippery slope because if you look at how the Act has been interpreted over the years, a small intervention can balloon into a massive scope of judicial interference. Let me give you an example. In the case of ONGC versus SAW pipes in 2003, this was again something which was not there in Section 34 of the Act. The court held that in addition to the various grounds mentioned in Section 34, a court could set aside an award which was patently illegal. Now, that's fair enough because logic dictates that something which is patently illegal should not be upheld or endorsed by the courts. But what is patently illegal is inherently subjective. So now if you look at it, there is really no difference between an appellate power and the court exercising this power to set aside an arbitral award on the ground of patent illegality. There is a judgment of the Supreme Court which says if an arbitral award does not apply or wrongly applies a judgment of a High Court or a Supreme Court, it is capable of being set aside. That's an error of law review. That's an appellate power. So therefore, I'm not sanguine about saying that, well, these powers of modification can be used only in narrow circumstances. It doesn't really happen that way. And I think the best contradiction in the judgment of the Supreme Court is the fact that it relied on Article 142. Now, if you have the power in a statute to modify an arbitral award, you don't need 142 at all. So why would you then have 142? Because I think the judges were conscious that there is no statutory right to modify. And then how does that actually operate in practice? A commercial court can modify an arbitral award exercising powers under the Arbitration Act. The High Court can. But when it reaches the Supreme Court is not actually applying Section 34 or 37 or 137. It's actually applying 142 as the source of power. I mean, just doesn't make logical sense at all. So in many, many ways, I think the judgment of Justice Vishwanathan is probably a much better judgment. And in reference to Section 33 and 34.4, what he said was spot on. He said there are safety valves in the Arbitration Act. So therefore, if there are typographical errors, if there are clerical errors, now these really can be corrected by going back to the arbitral tribunal or at the Section 34 stage. So if you don't avail of those safety valves, then really you go back to Section 4 of the Arbitration Act, which is if you had a right and you waived it, then you have only yourself to blame.
Okay, I'll just pick up on that last point he made on waiver, and there's actually a couple of portions in the judgment which I want to highlight. Going back also to the point that Jaya made on substantive justice, right? I think personally substantive justice is overstated in importance, and this whole procedure is the handmaiden of justice has probably led to a situation today where the Indian courts are backlogged to an extent where it's irredeemable. It's really going down to that. The minute we make peace with the fact that there is no such thing as absolute justice, there is only justice that is permissible within the procedural realm that you have created for yourself, you will be at peace with yourself. Otherwise, there will always be another round of appeal that you want, another round of curative, another round of review of the curative. It's an endless process, right? The reason I'm making that reference is if you look at 34.4, a power that the court very specifically looked at in the context of should I modify, should I remand? 34.4 they says, in sort of para 55 onwards, where it says either party may request remand to such a arbitral tribunal, and what is the scope of that? It may grant such an adjournment, allowing the arbitral tribunal to resume proceedings or take corrective measures to eliminate the ground for setting aside the award. So you now have the right to go back to the tribunal. Now, what can the tribunal do? It says the power of remand permits the court only to send the award to the tribunal for reconsideration of a specific aspect. It is not an open-ended process. Rather, it's a limited power confined to limited circumstances and the issues identified. Now, what can the tribunal do? One, it's limited, right? So you're not saying that I'm going to send you back and you just restart the whole process all over again. Go back on a limited point, and what can the tribunal do? The arbitral tribunal may proceed in a manner warranted by the situation, including recording additional evidence, affording a party an opportunity to present its case if previously denied, or taking any other corrective measures necessary to cure the defect. In contrast, the exercise of modification powers does not allow for such flexibility. So now think about it. If you're saying substantive justice, and you on the one hand have the power to send the parties back to the tribunal, who is the entity the parties have in the agreement chosen to decide the dispute, that entity's powers can be limited so that it doesn't become a rehashing of the entire thing. That entity has the power to collect evidence, to appreciate evidence and make suitable corrections. And on the other hand, you, the court, don't have any such power. Why would you then take it upon yourself to do, in what Jaya's words, substantive justice rather than send the parties back? And if the parties choose not to do that, point that Pramod was making, it's waiver. Right? You had at that point in time, when you filed the 34, the opportunity to be sent back to the arbitral tribunal. You've chosen not to do that. Why then should I rely on the courts to do this process, given everything that we've talked about in terms of the challenges of the courts doing it without no evidence, no additional evidence, no reappreciation, etc., and the sort of already overburdened judiciary. So I think really it is about balancing practicality with some degree of, deference to what the legislature wanted and intended for you to do.
Got it. I can clearly understand that Justice Vishwanathan is the favorite person of the panel here. So, moving to you, Anand. So, just taking forward with regards to the Article 142 itself, because that has been heavily criticized, the use of it, and Justice Vishwanathan also cautioned that the use is actually not right, considering that 34 and 37 are really narrow. So what do you think? What's going to happen now? Do you think it's like a controlled precedent, like pointed out by Vikas here? Or do you think it's just going to open the doors for the future overreach?
So if you look at the conclusions, the court, the majority decision itself, one, it is under 142, so the the commercial court cannot do anything, the high court cannot do anything. The only one who can actually do this is the Supreme Court. But just from experience, the minute you open the door, people find creative ways of trying to, once you have your foot in the door, people find creative ways of trying to open that door much further. So I think most people agree that one way or the other, the act has to be amended. If this is what the Supreme Court thinks the act is, then the government has to step in and either clarify, saying that no, you do not have this inherent power either. I don't know how they can do it when the Supreme Court wants to exercise 142, but yes, you can make it clear. Or two, say that yes, okay, there are limited circumstances in which parties can approach courts and in which courts can intervene, and this is the nature of the intervention that is permissible, as opposed to the court trying to read between the lines when there's nothing there and coming up with its own process.
Got it. And those creative people, three of them might be sitting here for sure.
Can
Absolutely.
I just make a counterpoint
Yes,
to
please.
what Anind said? And I think this is where already the confusion starts. Anand's reading of the judgment is that the only power of modification is traceable to Article 142, which means that only the Supreme Court can modify. Now, I don't think that's what the judgment says. The judgment says that the limited power to modify can be found in Section 34. So therefore, a Section 34 court can modify. Possibly, since a Section 37 is an appeal, the appellate court can modify. And if it goes to the Supreme Court, again, by virtue of being an appellate court, even without going into 142, could modify. So who can modify is going to be an interesting question. The second question is, in many ways, let's assume that if the law that is clarified by the Supreme Court subsequently to address this ambiguity is that only the Supreme Court can modify, what it does then is it gives people an incentive to get all the way to the Supreme Court. If you've looked at empirical evidence in other jurisdictions, I think around 90% of arbitral awards are enforced and complied with voluntarily, without the need for a judicial intervention. The statistic in India is different, and I think one reason why people would go, because let's say that let's take a chance. And what you can do at the very minimum is to postpone the enforceability of the arbitral award. And because before the 2015 amendments from 1996 to 2015, the moment you challenged an arbitration award, the arbitration award was consigned to cold storage until the challenge to the arbitral award was finally decided by 3 or 4 layers of the court process. Now, what this does is again create an incentive for parties to litigate an arbitral award all the way to the Supreme Court. So therefore, an arbitration award, like you mentioned, is not anymore final and binding on the parties, which is what the parties' agreement was. It is the first step of the litigation process. And if you were therefore advising commercial parties, and I'm sure Anand does a lot of that, I think the answer today really should be that don't arbitrate, because you actually have one more layer of the court process. You might as well go straight to the commercial court, have a suit filed in the commercial court, rather than go to an arbitral tribunal, probably make a side visit to the High Court to get an arbitral tribunal constituted, which can sometimes take 2 or 3 years, then have the arbitral award challenged before a commercial court, and then before the High Court in a Section 37 proceeding, and then before the Supreme Court. You might as well go to the commercial court and be resigned to the fact fact that, okay, you brought down the litigation process from 15 years to 10 years, rather than the 12 to 18-month period, which is what the arbitration process is intended to take.
This actually reminded me of an incident which very recently happened with me. So I was trying to call an industry expert for a session with us, and I said the topic is around arbitration and the use of AI and digital tools. So the first thing that industry experts said to me that I'm not in favor of arbitration anymore. I would rather prefer commercial court, and whosoever is coming to me, I'm advising the same. So I think if maybe, if things like that, as you pointed it out, might happen, you never know. I might hear such kind of things more.
No, but even before the decision, the largest litigant in the country, which is the government, has chosen to say that only certain disputes, which at least it believes to be below a particular threshold, should be sent to arbitration. They're relooking at whether arbitration clauses should be included in contracts or not, because they believe that they're not getting enough of judicial remedies. They're not getting access to the courts. So it has a flip side as well. People may choose not to do it because, like Pramod said, the arbitration is your first level before you go to your commercial court, so start in commercial court. While other people are choosing not to deal with arbitration, saying that in a high-value matter, I rely on the tribunal to pass a decision. And even errors within jurisdiction cannot be interfered with. And therefore, I do not want to be stuck in a situation where errors made within jurisdiction by the tribunal, it is a big matter as far as the government is concerned, and I don't want to have to go through arbitration only to be told I'm left remediless. So it works both ways.
Sorry, one small point I want to make. When Pramod was talking about all courts having the power, there's actually one very significant ruling which I think will have a very direct impact practically. The court directly recognizes that post-award interest may be modified in some circumstances. As a litigant, as a lawyer in litigation, let me tell you, in a good 50-60% of the cases, post-award interest is often more than the principal. If this specific power is given, the incentive of parties to keep going to court is very directly there, because you're not really hoping, what is the worst that can happen, right? The court will only reduce. If you look at it, tribunals, only good tribunals, commercially minded ones may grant you like 12-18% because that's consistent with commercial reality. But if you look at courts, 6%. 3%. That's their default, because that's what they do in civil cases. So you always think that you have a better chance going to court and getting this modified. When the court is saying limited intervention and it in the same breath is saying post-award interest specifically can be modified, it's essentially saying all litigants please go to court. It's just an invitation to do that.
Right, agreed. The 4 exceptions itself are like really, really wide, which can be interpreted in any ways. So actually, with Dr. Jaya, moving to you, that this is actually highlighted that if such kind of practices happen, then though we feel that India is moving towards pro-arbitration, now I really feel that that's something which I teach theoretically only. But do you think jurisdictions like UK and Singapore, those who are actually considered as very friendly seats to say so, they also have a very specific provision with regards to the modification, but they do have it very clearly written expressly. Do you think to actually curtail such situation, either we need such express provision or the clear demarcation, or how do we go about it?
About this particular case here, the court has acknowledged the fact that Section 34 or the Act as it is does not explicitly grant any scope for a judicial intervention, when it comes to modification of an award or so. But at the same time, Section 5 is a very general statement. It says that the scope of judicial intervention shall be limited, something like that. Scope and extent of judicial intervention shall be very limited. So here, it doesn't talk about a situation wherein the courts should not take up the role of a facilitator for arbitration. It says that certain circumstances, certain cases, it shall be. But at the same time, looking at this particular case, I think I would prefer to argue in favor of court intervention in the context of, as I said, he was talking about the substantive justice part in it. But still, in certain cases, strictly setting aside an award could be very disproportionately, it could be very disastrous in terms of claimants, what we can say, claimants' expectations, not only interest in the expectations, because they go for arbitration with certain, expectations and certain, of course, the court reality, we all know what happens in the ordinary courts. So in that case, here also I think the court has tried to modify the award rather than setting it aside, or rather than going or remitting the award for a re-arbitration, just to maintain or just to uphold the integrity of that process, to give it a finality. That is it. At least the award is final. That's it. And so that I would prefer to read it in that way. But coming back to your question about, of course, the legislative clarity, legislature should intervene, and clarity is much required. Because Article 142 is, we often, refer to 142 as a declared law. Like when there is an absence of law, the court has the power to come up with certain rulings which would be treated as a law until the actual law is made, right, by the parliament. So this scenario also, the legislative interference is much sought after, and jurisdictions which you mentioned about Singapore, Hong Kong, or in UK for that matter, I think modification, the limits, the borders are well defined, and also the standards, and there is predictability and consistency when it comes to court interference. So that aspect probably with a legislative amendment we could bring in. So that's what I think. Yeah.
Anind, if I can just ask the same thing to you, what do you think, if you would like to suggest something from jurisdictions like UK and Singapore who already are dealing such things, what could be taken up so that we can go in a right direction? Maybe I would like to hear this from all three of you.
I don't think you're going to find a very happy balance saying that this is the amount of judicial intervention that should be permitted, because you may put it on paper saying it should be limited. The initial unamended 34, when it was passed in 1996, was meant to be limited. But like Pramod mentioned in Saw Pipes, they said public policy means the laws of India, and therefore anything that is against any law in India can be reviewed. So, one, yes, I believe that you have to be able to give, at the end of the day, it's party autonomy. If you make arbitration this flip a coin, once the arbitrator decided, you have to live with the decision whether it is right or wrong. I think a lot of parties are not comfortable with that. Again, going back to what Pramod said right at the beginning, arbitration in India is not a vote in favor of arbitration, it's a vote against the fact that Indian courts take as long as they do. If our court system would work much faster, if we could go through the system of court with the elaborate checks and balances, processes laid down in the CPC, and finish a matter much faster, I don't think a lot of people would end up going to arbitration. We ended up going to arbitration because the courts are so slow. We looked at arbitration as being a faster process, but you appoint the same retired judges from court. You follow in the arbitral process, at least in the domestic arbitration, not talking about international commercial arbitration, you follow pretty much the same process because the retired judge only knows that process. So what have you done? You try to privatize the court system. I think there'll be a lot of people who will be happy if there's at least a limited set of grounds under which you can have the award looked at. Of course, the fear that exists, which a lot of our clients have as well, is that this will turn into what should be a 2-year process will turn into another 15-year process. Then you might as well go to the commercial court and start. But I believe that there should be some amount of at least ability to interfere, which is narrow. But knowing how our courts operate, we know that narrow window will be widened.
So because for you also, he had a very demotivating statement that our courts cannot do anything. So what do you think, what is different there practically?
I think I'll go back to party autonomy. Right? If you look at both Singapore and UK, they both have a limited right in which the court can vary, set aside, modify, but it makes it specifically contingent on the parties choosing otherwise. So, very regularly, while I was in London when we were advising on arbitration clauses, a standard term was London seated, Arbitration Act will apply, we contract out of the court's power to hear questions of law appeals. That choice given to the parties, I think, is a good balance that we can adopt from some of these jurisdictions. Even if you do feel, for the reasons that Anand said, that there may be certain reasons why you want some grounds, legislatively define it, put boundaries, put guardrails so that there is some degree of consistency, and then allow the parties to say, if you don't want this process, you can contract out of it. I think that's a good balance in my view.
Just just sticking to this example, I think if you look at institutional arbitration rules, now most institutional arbitration rules, the ICC, the LCIA, the SIAC, etc., have a rule which says that by consenting to arbitrate under these rules, the parties have consented to waiver of any form of judicial recourse against the award. But of course, they qualified by saying, insofar as such waiver may validly be made. Such a waiver will be enforced by the English courts, it will be enforced by the Singaporean courts, it will not be enforced by the Indian courts, right? Because Section 34 is considered to be something which is non-waivable, non-derogable by consent of the parties. Also, if you look at the provisions of the Singapore Arbitration Act, and Singapore actually has two arbitration acts, one for domestic arbitrations and one for international arbitrations. England has an arbitration act, Section 69, which provides for an appeal on a point of law. It is not a power of reviewing the award on merits. It's a question of law which has to be settled by a decision of the court. And that's a very restricted and a restrictive form of appeal which is available. Now, if you ask me what needs to change in the arbitration ecosystem, I think two things to my mind. Firstly, I think the quality of arbitrators must improve. I think, as Anand mentioned, your point, retired judges, there's nothing wrong with retired judges. I think there are some fantastic retired judges. I've had the honor of sitting with many of them, and they're excellent. They can be better than many of the arbitrators that you see internationally. And I've seen a lot of international arbitrators who are terrible, and who also, in a sense, are less than neutral. So therefore, I don't think we can generalize and say that Indian arbitrators are less competent or more corrupt as compared to their foreign counterparts. I don't think that is the case. But what we definitely need to do is to invest in an ecosystem where you have good quality arbitration awards. And that has a huge cascading effect. The reason why courts are finding one way or the other to interfere with arbitral awards is because some of the arbitral awards which come before the courts are of really dubious quality. And the judges then think that, well, this is an arbitral award that has been improperly procured. I am shackled by Section 34, I'm shackled by Section 37. So therefore, I'm going to find creative ways to try and break down the guardrails that don't allow me to interfere with arbitration awards. And that's typically how a judge decides. Because you decide the justice of a case first, and you say that I need to do something here, and then you find a legal route to get there. So the moment you improve the quality of decision making, automatically you have much better or more restrictive forms of judicial interference. The second, and I think probably something which will follow on from the first, and a point which Malhar made in the beginning, is that this debate may be just normative. I don't think so. The Indian experience has always been, and especially with respect to this enactment, that no question is settled until the maximum number of judges in the Supreme Court rule on it. So you've had decisions where, for example, the Indian courts said that it had no power to interfere with an arbitration which was seated outside India. Now that was changed in Bhatia International, and it went from a 2-judge bench then to a 5-judge bench to a 7-judge bench which decided the issue. Whether stamp duty needs to be paid on an arbitration agreement was decided first by a 2-judge bench, a 3-judge bench, a 5-judge bench, and then eventually by a 7-judge bench. Whether the power of appointing arbitrators under Section 11 is a judicial act or an administrative act, again, is a matter that traveled from a 2-judge bench all the way, I think, to a 5 or a 7-judge bench. So, what is nice about the Gayatri Balasamy, probably the only nice thing about the judgment other than the dissent, is that it is a judgment of 5 judges, which means that it may well not be the last word on it. But I'm making a reference to this because if you look at what happens in the more established, or what are often referred to as the safer arbitral seats, they have a constant and a consistent body of jurisprudence. Now, what you have by this judicial gymnastics of 1-2-judge bench judgment being reversed by a 3-judge bench, which is then again turned, overturned by a 5-judge bench, or what happened in the Delhi Metro case, which is the arbitral award was initially set aside, then upheld by the Delhi High Court, and then again overturned by the Supreme. That decision was upheld by the Supreme Court. A review petition was dismissed, and then the Supreme Court, in exercise of its curative powers, set aside the arbitral award with no recourse available for the other party. So what then suffers is the certainty of the process, and what commercial parties often want is certainty. They want a dispute to be resolved in a particular time frame, in a commercially viable time frame. It shouldn't take 10 or 15 years, and then you move on. Sometimes you have to take it on the chin. You may not not be happy with an award, but that's what you've bargained for. You've said that I want to have the ability to appoint an arbitrator who I have confidence in. Now, all arbitrators are human until, for example, Vikas and his team come up with AI decision making. But until that happens, the fact is that arbitrators can make mistakes and parties say, yes, we appointed a bad arbitrator, or we got a wrong outcome, or probably we didn't present our case as best as we could. But that's part of the game, and we move on. But what's happening here is that there's no question of law which is in that sense settled. And I'm saying this not only of commercial law, it's also true of public law. And it is this judicial uncertainty and judicial inconsistency, which probably is the biggest bugbear that India needs to confront and grapple with before it becomes an established arbitration seat.
Yeah, really nice take.
But just on the first point that you addressed, that limited ground to appeal question of law, our High Court frames 50 questions of law every morning before breakfast. So it's not going to reduce. It's not going to reduce the scope of challenge, at least in India, saying that frame a question of law. Questions of law of public importance, questions of law of substantive public importance are raised every single day in most court halls. So I don't know whether that in itself is going to be appropriate enough filter to say that no, this is a matter which because there's a question of law that this should be looked at, because our courts look at everything.
Okay, so I'll wait for the 7-judge bench now. So now let's pivot slightly, and we'll also talk about how arbitration can be something which is truly accessible, though now here people are saying that it shouldn't also happen if this is the case. But like this particular case where we are actually talking about increased oversight, which is actually happening. Do you think this is something which will instill a little bit of a confidence in the weaker party? And we can go ahead with you, Dr. Jaya. Do you think that people will feel that, okay, there is an oversight of the judiciary all the time, they are interfering?
See, the fact remains is that the judiciary is always been very particular about interfering with arbitral awards when it comes to matters of public interest, right? So talking about the MSMEs, definitely they have certain limitations with respect to their bargaining power, because they have limited resources, and also the necessary bargaining power which the private commercial parties do enjoy that they don't have, in fact. So I would say that the kind of legal support or the judicial support that is there in respect of MSMEs, I think they have a separate council now. The facilitation council is there, and they follow the method of arbitration for resolving the disputes. But of course, a legal support or the kind of a separate mechanism, by way of a specialized bar of arbitrators that we talk about. So at least to help them out with their kind of disputes, because they are mostly about, usually this council, they generally settle disputes related to payments. It's not much more than that. So if that could be done, that would be, I think, arbitration, kind of the present, the suggestive amendments, I think they are kind of maintaining an appellate tribunal for arbitration. Rather than going for such, kind of a separate ladder of settling disputes, I think the provision should be made for such a medium and small scale industries, so that they also can come up in the process of arbitration. At least they can navigate through the process.
I was actually looking at IIAC's special rules which have actually come for MSME arbitration. I really don't know whether everything has started, if any one of you have any sort of an experience with regards to that.
I'll address that, and I'll probably also talk about something that I'm doing personally which directly touches on the issue. IIAC has an MSME Council rules. There it is contingent on two things. Both of which I think make it really difficult for them to be really viable. But before that, the positives. The MSME rules have been promulgated specifically to deal with those kind of low-value disputes, and therefore the fees are significantly lower than the fee schedule. The timelines are much tighter. It is mostly on a documents-only basis. The amount of flexibility given in terms of conducting hearings, extensive cross-examination is more curtailed. So the idea really is to try and get to the nub of the matter as quickly as possible. So in theory, it's a fantastic idea. two roadblocks. Number one, very recently, I think about a week, 2 weeks ago, there was a judgment which came about which said that an arbitration clause cannot override an MSME facilitation council decision, which means that even if in an MSME kind of a dispute, you have an arbitration clause, the fact that there is an MSME facilitation council will mean that you can't go to arbitration, even if it is for under these rules. So the only way you can go to those rules is if the facilitation council makes a reference to the IASC of that dispute. And that is the biggest bottleneck. The MSME Facilitation Council, at least my experience, maybe the experience of my co-panelists is different, is a dysfunctional unit. You file a case, 2 years, 3 years, you don't know what's happened. Whether a facilitation council has appointed an arbitrator or not, you have absolutely no idea. So I don't expect them to be proactive to actually refer it out to the IASC to administer this dispute, right? So for me, I think the real bigger bottleneck is not as much in defining the process and making it smoother, but to remove that filter of that facilitation council, which is really holding everything up. Even in the facilitation council, if you just make some minor reform, just have more people, have a greater set of decision makers available to make a decision more quickly, that will solve the problem. But that's a very political problem, because who will make that decision, who will make the appointment, who will now benefit from all of these are things which are beyond at least my area of competence to answer. But until such time that bottleneck is there, the IISc rules will not achieve the potential that they have. But having said that, I want to talk about something I'm working on, and really have given up my legal practice to the greatest extent to focus on it, which is to make arbitration accessible to the masses. When I was reading arbitration, the only kind of arbitration cases I talked about was international commercial disputes where parties were trading across borders, and even in India you have your biggest companies dealing with arbitration. But then if you think about the course in which I studied it, it was a course on alternate dispute resolution. And it was such a stark contrast. And on the one hand, we're talking about lok adalats, mediation, conciliation, and then arbitration. So suddenly everything else is for the masses to try and really bridge the accessibility gap, but not arbitration. And that's how the courses are taught. That's how the judges read the law. That's how they interpret it. Like in their mind, they're always looking at, 10 crore plus or a 5 crore plus dispute. The institution I'm building is called the Center for Online Resolution of Disputes. We're looking at how we can use arbitration, the inherent flexibility of arbitration, to resolve the lowest value disputes. I can tell you that today we are resolving disputes at under 3,000 rupees a dispute, arbitrator fees, institution fees included, through arbitration, which has all the guardrails that I would, as a person building an institution, want to create in that time. We are resolving disputes in 45 to 60 days. Opportunity to present your case. We are allowing parties to present it remotely. In fact, there are a lot of people where we conduct hearings on a phone call because they don't have access to internet. They don't have access to WhatsApp or Zoom, any of those, right? And we conduct arbitration hearings in Bhojpuri, in Malayalam, because they don't understand English. They don't understand the concept. But that doesn't mean that they don't have something to say, right? And that really is where all the bad things that have been happening, or at least the discussion academically has been on in terms of what arbitration must achieve, etc. The minute you start distilling out all those problems into these kind of disputes, that's when you will say, these are the solutions that work, right? That married with the kind of discussion we were having today on substantial justice, they are not averse and contrary to each other. In my rules, we have an appellate arbitration. So even though you have disputes getting resolved at 3,000 rupees, I am conscious, unlike the New York Conventions, that arbitrators are not gods. The New York Conventions proceeds on the assumption that the arbitral tribunal always gets it right, or at least whatever they get it is what the parties must live with. But then I say, why should the parties live with it? There is no other service sector where the service provider is held to zero accountability, except arbitration. The arbitrator is the one service provider where you talk about immunity of arbitrators, immunity from prosecution. But if they get it horribly wrong, to an extent that, even at the very high threshold for setting aside an arbitral award, their awards get set aside, they copy-paste portions of an award and get away with impunity, talking in arbitration seminars post their awards getting set aside for such a terrible error. Where is the accountability? And that's where we thought of an institution where you'll say, we will give you arbitrators who are accessible, affordable, but we recognize that they will make mistakes. So out of 1,000 cases, maybe 20 cases they make a mistake. Those 20 cases, there is an appeal available to a more experienced practitioner who can distill out those issues. And if you look at the bill, the arbitration bill, it specifically envisages this kind of a framework. In fact, this is not even new to the arbitration bill. You take Centro Trade as an example. You take the Grain and Free Trade Association. You take the National Stock Exchange arbitration. You take the Cotton Trade Association. Every single industry body has recognized this problem and they've built this system, except our mainstream arbitration under the Arbitration Conciliation Act. So I wanted to say, when you talk of accessibility, it has nothing to do with arbitration inherently. Arbitration, I think, is a beautiful concept which is capable of being molded, except today the people who are molding it are saying, I will not mold it because I'm stuck in my ways of being a district judge and I'm too rigid to allow any sort of flexibility. But I think it's up to practitioners like all of them here, the people who are here leading policy initiatives, to say this is nothing inherent to arbitration. You can make it more viable, you can make it more accessible. Sorry for a slightly longish answer, but I wanted to say all of this.
No, thank you so much. This is something also even I felt it's a news for me, because as an individual, even I kind of believe, like just by seeing what is happening around, that arbitration, one of the questions where I'm supposed to ask that can ADR be considered as a legal aid tool? So here the very first thing which was there in my head was, under ADR, I should remove arbitration then, because then the remaining ones can only be considered as something which can be used as a legal aid tool. But like you pointed it out, so it's also something which I need to change in my perception that, okay, arbitration can also be used as a legal aid tool. So,
in fact, on that, sorry, just one last thing I wanted to mention. If you look at the initiatives in technology, and I want to talk about a couple of them, right? If you take some of the Agami initiatives, there is one particular project where domestic violence victims are given a particular WhatsApp number where you can speak in your language orally what your problem is. You use large language models to derive a legally, I don't want to say legal advice because that's impermissible under the Advocates Act, but some sort of direction in terms of what you can do. Take that same tool, put that into legal aid plus dispute resolution. Today we are looking at building solutions where anyone should be able to pick up their phone, in their voice, explain in their words what their situation is, have AI tools ask them relevant questions back to say, okay, I understand this is your problem, am I correct? Can you give me, do you have any documents? Is this document available? Can you upload it? Just take a photograph, whatever, right? Those tools are available. So I think absolutely 100% ADR arbitration can become a very, very powerful tool in legal aid. Of course, not in public law, not in human rights, etc., because there is some degree of court supervision that is absolutely necessary. But otherwise, yes.
Thank you. Pramod, I'll just take a follow-up question with you, because as he's saying that ADR can, arbitration specifically, can be used as a legal aid tool. Do you think funding could be a big problem? There could be some people who might, as an arbitrator, be ready to do it, maybe a pro bono or with a minimal amount. But do you think practically, because we do not even have a very specific concept of state funding arbitration, so how do you think that's even possible?
I agree. I think funding could be a problem, especially because the larger value arbitrations, and for that matter, the more complex arbitrations, sometimes the smaller value arbitrations can raise a number of complicated questions. So I don't think the complexity is related to the value of a dispute. So, and an arbitration really has to go the full course, because otherwise the arbitrator can be criticized for not giving each party a full opportunity to present its case, which then in turn becomes a ground for setting aside the arbitral award. Yes, I think the burgeoning cost of arbitration is a concern. And there have been a number of solutions that have been suggested depending on the context. In the Delhi High Court, for instance, I think there was a proposal that was mooted to have something along the lines of legal aid for arbitrations, which is that if there is an impecunious litigant who is not able to afford the cost of litigation under the CPC and under the various High Court rules, such a litigant would be entitled to legal aid. Similarly, for arbitration, you can just extend the same analogy and make legal aid available have an army of legal aid lawyers empaneled for this purpose. They volunteer their time, they volunteer their effort, and legal aid is provided to somebody who is not able to afford the cost of an arbitration. But I think one thing that you need to also recognize is that arbitration works best when there's equality of bargaining power. Whenever there is that asymmetry in the power relationship, arbitration doesn't work as well. And for that reason, why you have rules of arbitrability, etc. So there are certain kinds of disputes which are not arbitrable, or even if they are arbitrable, for example, the MSME case, or it could be a case of an employer-employee dispute, or it could be a consumer against a big multinational corporation. In those contexts, the courts have tried to reduce the rigor of the binding nature of the arbitration agreement by saying that if you have a statutory remedy under the Industrial Disputes Act or under the MSME Act or under the Consumer Protection Act, arbitration is an option. You are not bound to arbitrate, because when you arbitrate, what you have to do, at least in the first instance, is to pay for the costs of the process, right? And if, for example, in a consumer dispute, if you, for example, go down the road and park at the Taj, the valet slip has an arbitration clause. Now, if you expect somebody who parks a car and that gets damaged to arbitrate against the Indian Hotels company, I mean, there's a mismatch of bargaining power there, right? So what courts have therefore done is they've said, and what parliaments across the world have done is to say that certain kinds of disputes are not arbitrable, and that is recognizing the inherent mismatch of the two contracting parties. And even in cases where a dispute is arbitrable, if there is a statutory remedy, then the arbitration agreement does not have the effect of ousting the statutory remedy. So therefore, the courts have done various things to try and make sure there's access to justice. Since you mentioned funding, in the arbitration context, something which has really gained a lot of traction in recent times is third-party funding. I'm not sure what the views of my panelists are, but I think this is probably not a great sign of things to come. The reason is a litigant commences a legal proceeding for justice. A funder funds litigation for profit. So whilst you should do all that you can to enable access to justice, I don't think the law, courts, legislators should bend over backwards to enable access to profits for a private corporation. And I've seen this play out in rather unhealthy ways in many ways. For example, when you represent states in an arbitration, you sometimes find that the investor, in the context of international investment law, the investor is supported by deep pockets. And therefore, even if the investor does want to settle a dispute at a particular stage, the right to settle a dispute at a particular stage of the proceedings is taken away from a litigant because a funder has a veto power over it. So in some cases, I think that enabling third-party funding, and of course there is a huge movement over it. Probably I'm in a minority because the entire arbitration world seems to be thinking that this is the best thing after sliced bread. But that said, I think given some of the pernicious effects of third-party funding, I wouldn't be terribly excited about India ushering in legal reform to enable and ensure third-party funding. That said, widening the scope of legal aid and make it accessible for arbitration. For example, even in the international investment law context, one of the reforms of ISDS, that is Investor State Dispute Settlement, that is being suggested and is in the process of being established, is to have an advisory center for investment law. You already have such a center in the context of WTO law, where less developed countries which are not able to fund litigation before the WTO and are not able to afford expensive lawyers and legal teams can go to the ACWL, and the ACWL then acts as the law firm and provides excellent quality of legal assistance for less developed states in the context of investment disputes, or in the context of trade disputes. And then there's a move afoot to have a similar body set up to provide representation for states from, let's say, sub-Saharan Africa and other states which are probably not able to really match arms with deeply funded investors in the context of investor-state disputes.
Thank you. So as Pramod mentioned about third-party funding, so let's hear our panelists' view on that, because this is something even I believe cannot be avoided. It's going to come. Of course, unfortunately, in the bill also, we didn't see any such a regulatory framework around it. But what's your take whether there has to be a proper regulatory framework around it, because there are a lot of legal or ethical consideration, as also pointed by Pramod here. So according to you, what we should do? We'll start with Vikas.
I'm a hardcore capitalist. I think the concept of justice for me is just too ephemeral to get my head around. I think there's certain benefits that a third-party funder comes in, which is an early evaluation of claims. I think when that happens, parties who are inherently emotionally invested in a dispute are able to distance themselves out a little bit and say, listen, if a third-party funder is saying that this is not a great claim, or if a third-party funder is saying there's a good case, at least there is a more objective determination by someone who has a very direct interest in the outcome driving that. So I think that can help reduce litigation, at least frivolous litigation. So there is a certain benefit to it. Taking control away from the parties, frankly, I think when you're looking at access to justice kind of initiatives, when people have the option between either I don't have the money to fight it, or I don't have the money to settle it on terms that might be great for me, I would probably choose in favor of saying at least you'll get something out of it. That said, there needs to be some guardrails. There need to be some sort of regulations as to what is permitted, what is not permitted. Particularly in the context of arbitration, disclosures become particularly relevant because then if there is a third-party funder, conflict declaration of arbitrators becomes important. Are there multiple similar cases they're handling? What is the impact of it? Those aspects start becoming relevant. But I think so long as we trust the tribunal to take note of these factors, having been appraised of them, and conduct the proceedings in a manner which is appropriate for an efficacious resolution, I don't have personally a problem with third-party funding.
I'm somewhere in the middle.
Good for us.
Yeah, which is basically a third-party funding organization, like Pramod mentioned, has a particular view. It will look to deploy its money on matters where it believes that it has the best case, which means that no marginal case is going to be taken up by a third-party funding organization. Now, like Vikas said, that means that that somebody will look at it and say, okay, my case doesn't seem to be good enough for the third-party funder to back. Doesn't in itself mean that my case does not have merit. It's just something where he does not want to put the money down because it's money going out of his pocket. He wants somewhat of a certain return. But again, taking from what Vikas says, you can't just have third-party funding coming in and saying, okay, now you have third-party funding. There definitely has to be rules around what they can fund, the extent to which they get involved in the process, and there has to be disclosures.
Dr. Jaya?
Yes, my thoughts are also in the same line. Like for third-party funding, definitely there should be proper regulatory framework if it is to be introduced. As of now, we don't have any kind of statutory recognition for it, but the courts haven't denied it also. So about the ethical and legal considerations, I think the disclosure standards, the confidentiality, because they often have the power to kind of control the whole proceedings, especially when the parties are not directly involved in the process. So I think considering the legal and ethical considerations, a regulatory framework would be an ideal solution. And many other countries like Singapore and I think Hong Kong, they do have a regulatory framework for this third-party funding, etc. And coming to arbitration, this is obviously a recognized way of funding the claims. So it should be allowed. Yeah.
When you're talking of third-party funding, I think it's worth also talking about contingency fee arrangements, because the biggest third-party funder today in litigation is the lawyer. Today in India, it is prohibited, but 80% of the litigation in India is on a contingency fee basis. So this is a bit like how it was in Netherlands, where there's so much rampant use of marijuana that if you try and prohibit it, then you're not regulating it. Everything is going under the market, right? So it really is important to recognize the ground realities and say this is what is happening. And because you've made it illegal, none of these are documented, none of these are enforceable. So you're actually making the parties who you're trying to protect by prohibiting contingency fee arrangements suffer because you've made it illegal. You would much rather legalize it, put guardrails, put restrictions, saying this is done, this is not done, rather than turn a blind eye to what is evidently the reality for almost every litigant, except for maybe the creme de la creme, that the kinds that Pramod and Anind handle.
So moving on to our last question, and that's something I'm asking out of my selfish interest, because this is something we always, in the class when we kind of discuss, we try to dissect the act and say, oh, this is wrong, this is right, this needs to happen. So, and, as the amendment bill was also there, we are saying, oh, this is wrong, this is right, patent illegality or emergency arbitrator. So if I ask all of you, just that one thing which you would either like to change or add in the act, what will it be? We can start with you, Pramod. And I'll take all these notes so that in the next class I can say, oh, these are the 4 things which are very vital.
Let me answer it differently. I wouldn't change a thing because I don't see anything inherently wrong in the legislation. And I think over the last 30 years, all the problems that you've seen are either because of excessive judicial intervention or opportunistic parties trying to have a second bite at the cherry, or a situation where you have people who are trying to game the process, and that is in a sense being facilitated or allowed by the various judicial bodies, regulators, etc. So I don't see any limitation, flaw, or drawback in the arbitration statute. I would not have, in that sense, also probably chosen to go for the amendments in 2015 and 2018, except for one, which I think in the Indian context has worked really well. And I thought at that time it was an excessive intrusion into party autonomy, which is the introduction of a timeline for arbitration. I don't think any other arbitration legislation anywhere else in the world has a timeline for an arbitration from start to finish. Earlier it was 12 months, now it is probably 12 plus 6, 18 months. And I think it's worked incredibly well in the Indian context in order to discipline arbitrators and facilitate expediency in proceedings. So let me answer the question a little differently by saying that I would not change a thing.
Okay. Vikas?
There is one aspect of the Arbitration Act that really, 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 really irks me, which is the courts appointing arbitrators. I think we should go down the path that the Singapore courts have done, which is essentially delegate that power. Because I think that, for me, is the one point which is probably at the root cause of every problem that we have encountered. If you have good, credible institutions making an appointment with their reputations on the line, with visibility as to availability of arbitrators, with visibility as to the quality of their awards, their timeliness, the responsiveness to parties, that appointment, and there obviously these institutions have an incentive then to appoint younger arbitrators who are not necessarily judges, who are more experienced. I think that one change can actually have a very, very significant impact overall.
That's an interesting one because you're asking for one change.
So like none, and I think umpteen.
Yeah. No, I believe in, like, again, taking off from what Pramod had to say, is that the Act has been amended several times, and every time an amendment has been made, it is trying to fill a lacuna that seems to have come out of judicial interpretation. One thing that I'd really want to see is arbitrations being administered better. But that goes to one. It's not always institutional. Ad hoc arbitrations need to be dealt with in a much better manner than they are currently being dealt with. So there are of course changes, but I can't tell you of one.
For me, the first and the foremost change that I would like to see in arbitration law is about bringing in more accountability for arbitrators. I think they are still outside the purview of judicial hierarchy, and also to set up specialized bar of arbitrators, as we always say, so it should be there. But again, some age limit, some kind of a restriction as to who can be an arbitrator, and what of experience should be there. Some, to bring in more accountability that way. Yeah.
So at least your one wish has been fulfilled. There is a bar which has come up, even for the mediation, the other bar. So for arbitration and mediation. So let's see where it goes. But thank you so much. It was wonderful talking to all of you here. But before closing, I think we should move ahead to the audience question and answer. So, all yours.
Sorry.
So, since we spoke on the lines of modified award, my question is more with respect to enforcement. Let's say there's a modified award that has come in place, and then there's the original award that's there. What is the fate of both? So that challenge proceedings actually have an impact on the enforcement proceedings, which can go simultaneously. So, if panelists can throw some light on that, because if there are two awards, basically, one is like modified and one is the original, it's really something where we look at.
Could I just answer that? I think it's a fascinating question. And I think it's a point that was made in passing to the Supreme Court, and I don't think the Supreme Court got it at all. Now, if you look at one half of the Arbitration Act, which is Part 2, what Part 2 does is it gives effect to the New York Convention as a matter of Indian law. So it transforms an international treaty, which is the New York Convention, and makes it part of Indian law. So that's what Part 2 does. So the question that you've asked is in terms of what happens to an arbitral award if it is modified by an Indian court. So a comparable question has arisen in the context of the New York Convention is because a New York Convention award is like a US dollar, right? It's convertible, it's easily transportable across all borders. There are probably close to 170 countries which have signed up to the New York Convention. And an arbitral award rendered, let's say in India, which is a New York Convention country, can be enforced in 169 other jurisdictions worldwide. So if that happens, if the Indian courts set aside an arbitral award, can an award that is annulled at the courts of the seat be implemented elsewhere? And I think especially the French courts have taken the view that we can take an independent view of it, and even an annulled award can be enforced if we believe that the award doesn't suffer from the other vices of the New York Convention, Article 5, which is that, again, essentially the same Section 34 grounds. Now, this was a point which I think was made to the Supreme Court, I don't think very well, but anyway, the Supreme Court simply did not get it. The question is essentially the same. Now, if the Indian courts were not to annul an arbitral award, but were to modify an arbitral award, and the same award can be modified in any other jurisdiction where the award debtor has assets. Now, if you take the same award to France, what would the French courts enforce? Would they enforce the award as modified by the decision of the Indian courts, or would they enforce the original award? And I think they would probably take the view that we are not bound by the modification decision of the Indian courts. We believe that courts do not really have the power to modify an arbitral award under the New York Convention. And as a matter of public international law, you can't rely on a domestic statute or a provision or a judgment to, in a sense, deviate or violate your international law obligations. So therefore, we don't believe that what the Indian courts have done is permissible under the New York Convention, and therefore we are going to enforce the unmodified award. But all those are probably issues that are going to rise once the Pandora's box has been opened in Gayatri Balasamy. You'll have this and many other issues coming to the fore going forward. I hope to be proved wrong, but I'm not very optimistic about it.
Can I just add to what Sir said? I think it's also a concept of double executor that comes in a landmark judgment of Kutrubali. So probably it's like decided long time ago to second your opinion on that, sir. But then now that Gayatri Balaswamy's judgment is opened up to this extent, even if there's a judgment that's already set in, and then there's an a challenge petition that comes in, and the parties wants to choose which one to prefer for. I think more or less, except for France, most of the countries who are bound by arbitral law than one law countries, they go by this concept of double executor, and then that answers his question of, not choosing what they want, but at least going by what is the right.
Yeah, so you have two options that are available to a party which succeeded in the arbitration, but is unfortunately having to deal with an award being modified by, let's say, the Indian courts. One option is to execute the arbitral award outside India, and probably the way I see it, I don't think any other pro-arbitration seat will essentially feel compelled to enforce only the modified award, they may enforce the unmodified award. The second option, and this is again going to be a problem area for India, is you've seen the growth of international investment law jurisprudence move in a direction which says that contractual rights are assets. So if you have a contractual right to, let's say, interest at 12% or 14%, that's a contractual right that you have. You've had decisions in Saipem versus Bangladesh and others which have indicated that an arbitral award in that sense is an investment, it's an asset. Now, if you have courts modify contractual rights and reduce interest from 12% to, let's say, 6% or 3%, or you have them modify any other parts of an arbitration award, that can be considered to be an expropriation of a contractual right. It's happened in the context of white industries where India was held responsible for delayed enforcement of an arbitration award. And I think the writing is on the wall that if Indian courts interfere with arbitration awards on this basis, it's possible that it could be viewed as an expropriation of an investment, of a contractual right, and that can engage state responsibility for the Republic of India for the actions of its courts. So if you want to have a list of pessimistic things, that could be, I think we could probably go on all evening and probably not do much more than skim the surface.
I have another question. I think this is more to do with making arbitration available for the masses. Since we spoke a little bit about investment arbitration as well, there's been a lot of debate about if investment arbitration majoritively has to deal with something that affects the local communities. An investor investing in a state or entering into a venture or project, and the project ideally affects those local communities. Things go wrong, the investor and the state have arbitration as a forum, but local communities don't. They are merely observers, not participators. Is there anything that can be done to ensure that these rights are also addressed? Because, right, like Sir rightly stated, that making arbitration for people who are having disputes under 3,000, can this also be seen as something at a much more higher scale?
I think that's probably a question that Pramod can answer better, because it probably goes into questions of transparency in investment treaty arbitration, amicus curiae briefs, etc., which you have significantly more experience in.
So exactly. So I think what can be done and what has been done is this. Of course, when you have the perpetual respondent in an investment treaty arbitration, which is the state. The state is never the claimant. The state is always the respondent. And the state, in that sense, is the custodian of all the interests of the society that it represents. So when the state represents itself in the arbitration, it is also deemed to be representing the local communities, federal units, etc., etc. But that said, what has happened in the context of investment arbitration law is the move towards transparency. And one very interesting and exciting development has been the entry into force of the Mauritius Convention. So for states that have signed up to the Mauritius Convention, the Mauritius Convention provisions apply to every investment treaty arbitration that they are engaged in after the entry into force of the Mauritius Convention. So this enables third parties to participate. So a third party, which could be a local community, for example, aggrieved by pollutants being let in by a foreign investor into a river. The license of the investor may have been revoked by the state, which is probably the subject matter of the investment treaty arbitration. But in order to demonstrate the ill effects of the functioning of the investor, it is possible for local communities to petition the International Arbitral Tribunal and file an amicus curiae briefs. Now that's been permitted, I think, for probably the last 20 odd years. So they can file a brief, they can participate in hearings. And what's really fascinating about investment arbitration as compared to commercial arbitration is investment arbitration is a lot more open, it's a lot more transparent, and it's a lot less confidential. So if you go to the ICSID website, you pretty much know about the existence of different kinds of arbitration that you have against a particular state. You don't have that in the context. If the same proceeding were to be held before the LCIA or the ICC or the SIAC, you would struggle to even ascertain the existence of the arbitration. But now you can ascertain the existence of the arbitration. You can find out the filings made by the various parties. Statements of claim are sometimes uploaded. And you have the ability to participate in these proceedings as a local community. And I think this is probably one of the better set of reforms that have happened in the context of ISDS over the last few years.
I think I had to say.
Do you think do you think we are in India, we would do better differentiating between the domestic arbitrations and arbitrations that have international ramifications, as in the case of Singapore? Because at most of our discussion, we have an issue with enforcement of awards in foreign jurisdictions, and same problem would not arise in a domestic arbitration. So do you think we do better if we clear our heads, have two different legislations for specialized arbitrations like investment arbitration and domestic arbitration?
Okay, I had actually committed myself to a position when I responded to the question about whether you'd like to have a change introduced, and I said no change is introduced. But if I were to make a change, what I would do is to probably have two separate enactments. One for, in that sense, domestic arbitrations, and there could be a debate about whether it applies to all domestic arbitrations, including international commercial arbitration seated in India, and the second, which is for enforcement of arbitration awards. I think it is something which can certainly be considered, and I think it can be a move for the good. I think it's possible to have probably a greater scope of judicial interference, at least for the short to medium term, till standards of arbitration improve in the Indian context, where I don't think it's a bad idea for Indian courts to have the power to set aside an arbitration award for patent illegality in the Indian context, because you see some terrible awards. And I think it really would shock the judicial conscience to give the judicial seal of approval to the enforcement of such awards. So until standards improve, I think it's a great thing to do. What it can also do is it can improve a lot of the quality of jurisprudence. Let me just give you one example of what I mean by that. The act that we have today is based on the legislative template of the 1985 Ancestral Model Law. The 1985 Ancestral Model Law was designed as a template for legislation for international commercial arbitrations and for enforcement of those arbitration awards. We took it and applied it whole scale even for domestic arbitrations. Now, how does that create a problem? Let me give you just one example. One of the more contested issues in Indian arbitration jurisprudence is how do you determine the seat of an arbitration? How do you determine the venue? And to my mind, I think that idea is, that whole debate has largely been nonsensical, because in private international law, a seat is not a city. Bangalore is not a seat of arbitration. Mumbai is not the seat of arbitration. Delhi is not. India is the seat of arbitration because it's a legal system. A legal seat is not a place. It is not a venue. It's not a physical space. It's a legal system. So the legal system is the Indian legal system. But you've had so many, I think probably tens and hundreds of judgments which have grappled with what is the appropriate seat of arbitration. Do the courts in Mumbai have the power to appoint arbitrators where the parties are based in Bangalore, in Delhi, etc., etc. And you've had judgments of the Supreme Court. So all these issues have traveled all the way to the Supreme Court. And I think a lot of this conceptual confusion happens because under the Ancestral Model Law, the seat is really a legal system which has to be chosen by the arbitral tribunal if the parties have not specified it. And that is to find a solution in private international law to a problem where the parties have not expressly designated a seat. But you can't use the same principle to identify a domestic seat. That solution is to be found in the Code of Civil Procedure. What is the appropriate court having jurisdiction over an arbitration has to be determined by virtue of the provisions of the CPC. Where does the cause of action arise? Where do the parties reside? All those tests that you have in section 16 to 20 of the CPC. But we've taken concepts of private international law and applied it in domestic law where it is not intended to be applied. And that's why you have this entire confusion about what is the seat of the arbitration. So yes, if we could have one change, I think having a separate legislation for domestic arbitration and international arbitration would be a great thing.
Sorry, I have a slightly different view on a couple of aspects, right? One, I think the concept of seat, he is absolutely right. Under the Ancestral Model Law, it's the legal system that you're choosing. But I think given the disparity of competences and awareness to commercial disputes across various courts in India, I think that question is still actually relevant from a very practical point of view. Whether I go, and I've had this experience, to a district court in Nelamangala for an international commercial arbitration, or whether I am before the Delhi High Court, makes a very significant difference to ultimately what I'm able to achieve there. So while yes, maybe the use of the word seat may be a little questionable, I think it really parties deserve the benefit of having the ability to choose a particular court which will have some supervisory jurisdiction over them, because I think that is a consequence of a seat which cannot be ignored. The second, and I agree with him in part, but I think I want to make a slight modification, is maybe instead of two, I would talk about three, which is one for investment treaty, one for international, one for domestic. Actually, I don't want one for international and one for domestic. I want to call them something else, because two Indian domestic parties can be extremely sophisticated and may want a light touch regime. Whereas, if you say there is one international regime, one domestic regime, you're force-fitting Indian parties into the mold of you are an inexperienced arbitration player. You don't understand how arbitration law is. Therefore, I'll give you greater oversight, greater judicial intervention. I think that maybe is doing disservice to some sophisticated parties. So while I'm absolutely in favor of a dual regime, I would want it to be a regime based on competences. And I think that's where something that the Singapore government, that's why I was quickly checking, has some, I think it has some appeal to me, which is the parties can choose the regime. In Singapore, irrespective of whether you're an international commercial arbitration or a domestic arbitration act, you can choose to say, I will be governed by the regime under the International Arbitration Act. If you give that, then what will happen is you can say the default is that you'll have the more intrusive regime, which is for domestic parties where, whatever, given the lack of awareness, given the lack of sophistication, and what Pramod talked about, quality of awards is 2000% accurate. We have some terrible awards. So that could be the default regime. But the minute you have slightly more sophisticated parties, you can tell them, you don't need to go with that system. You can go for something which is a little more light touch. Or like, let's say the English court system says, you can opt out of certain provisions. So just giving them a little bit of a bouquet, I think, gives you a little more credence to party autonomy while trying to balance those competing interests.
So can two Singaporean parties do that in Singapore?
That's exactly what I was checking.
I probably don't think so. If the arbitration has an international flavor, yes. But if it's purely domestic, the answer should be no.
I'm going to rest on your view on that one. My understanding is that there is an ability to choose when there is two regimes available. Whether it is also available when there are two Singapore parties with zero foreign connection, I need to do some research on it. But frankly, I don't need to be guided by what Singapore does also. I was just giving that as an example of what I think is conceptually something that appeals to me. If tomorrow, and I don't know, a Reliance were to be getting into a contract with an Adani to build a port in India for Indian people, they're two very sophisticated parties, probably advised by the best of law firms, potentially these two people on both sides of the equation. Why should they be subject to the treatment that a poor farmer is getting into an arbitration agreement potentially drafted by me? You don't need to, right? You really have to recognize that competence is what decides the need for a different regime, not the nationality. Yeah, and I think contrary to the popular perception, forum shopping is probably a good thing. Because for me, like I said, I'm a hardcore capitalist. Forum shopping encourages competence. If you see, why are people choosing Delhi for a lot of their IP trademark litigation? Because they have better judges there. Why would I then say, no, you can't go to Delhi, I will force you to go and to some smaller state where they probably don't have enough IP litigation? I think it's a good thing. You should encourage people to say that when there is an option, unless there's an overriding public interest, if there is questions of access to justice, if there is questions of language barriers, things like that, then I understand. Forum shopping is a difficult concept. But otherwise, I think forum shopping is a good thing.
I think to my knowledge, the recent amendment bill has some reference to this venue and seat.
Oh, sorry.
There is a controversy. I think this venue and seat controversy, I think the pending bill has some reference to it. I think that is
That what will be considered as venue, place, and seat.
And also, like this 1996 Act was a kind of a consolidation attempt with respect to domestic and international arbitration. So if you suggest two different regimes, so wouldn't it be like we're going back to the old regime?
The old regime did not make that distinction because the 1940 Act, by definition, didn't have Part 2 because
It was a Foreign Awards Recognition Act was there, yeah.
Yeah, that was an add-on.
Yeah.
Right? So the 1940 template was only for domestic awards.
Yeah, that was only for domestic. But two acts were in place, right? The domestic Awards Act, yeah.
And here I actually want to add on that in 1940 1940 Arbitration Act, actually there was a provision to modify award.
The reason you had to modify is because an arbitration award by itself was not self-executing. It was not a deemed decree. What you had to do was you had to file it in court, make it a decree. And then, so it's not a separate channel. You're diverting the stream into the river. That is part of the judicial process, right? It's a judicial decree. It is enforced as a judicial decree. The scheme of the 96 Act is these two streams are to be kept separate. At some points in time, that there is a dam that has to be erected, etc. There's a judicial dam that is erected, but that's about it. You don't make an arbitration award part of the judicial process. The judiciary is there to support the arbitration process, but the judiciary does not modify the arbitral award. That is the scheme of the act.
Right. So my question is on the subtopic with regard to whether arbitration can be a tool for legal aid. So one thing is to understand the accessibility that you mentioned that you and your team are working to ensure that everybody has the access to arbitration. And the other thing is to check on the affordability aspect of it. Considering the whole concept of 89 of CPC of ADR was to ensure that there is settlement and to avoid long litigation and the expenses that incurs with it. So initially when I started practice, I saw this BMC board which had boards saying if you settle in a mediation, then your 100% fees would be refunded. But now a couple of years ago, I see only 75% of the fees is refunded, which I understand on the institutional management aspects. So when we're looking at accessibility to the people where the indigenous person can also afford it, do you think there has to be some kind of a frame for the arbitration fee structure? Do we have to modify it? Because it's a myth to me to say arbitration is cost effective, where on the other side, I don't really find it to be very economical for everybody to afford it. So do you think that we should probably bring in some kind of a slab to make it not just accessible, but also affordable?
There are just so many different animals that fall within this
Yeah.
process.
Right.
What Vikas does, which is being able to do high volume, lower value arbitrations.
Right.
There are arbitrations that require arbitral tribunals
To do it.
put in the kind of effort that they need to on one single matter. So then to say that yes, I will have one slab, which some of our arbitration centers, for example, have.
Correct.
And as a result, even arbitrators who are empaneled on those centers
Don't want those fee structure to be maintained. So they don't want the uniformity. Of course, even in the Indian arbitration centers, each arbitration center has different fee structure that they follow and all of that. But considering it's changing, we're evolving and we want to make a difference and a change. I'm just looking at a ADR mechanism as a practitioner. It's very difficult, which I understand, but
the alternative definitely should be there. Yeah. Sorry, I'm not saying that the alternative should not exist. I think there should be alternatives at every single price point. Therefore, not pricing people out of the market, at the same time not disincentivizing arbitrators to actually put in the effort that is required for more complex matters.
Sorry on that, I'll go back to the institution, right? I've thought about some of these issues, that's why I go back to that reference. We have a slab where we have a different fee structure for what we call priority sector disputes, and we have a different fee structure for what we call standard disputes. Priority sector disputes are typically those which we regularly update that list and say these sectors we qualify as priority sector because they're very simple disputes from our experience, right? And therefore we are able to make those price points available. And equally, for instance, we've got under our rules a reference for a shareholder dispute of about 2.5 crore. That is not a priority sector dispute. That has reasonable fees sort of similar to what is there in the fourth schedule. So it is horses for courses. But having said that, there's a couple of other points that you made that I wanted to touch upon, which is legal aid and whether, Section 89, etc. Think about it very realistically. Even today, if you avail legal aid, are you spending zero money? Right? And that really is the answer. If you think about very practically speaking, yes, theoretically, justice should be free. But the reality is that it is not. So if you are saying that justice is not, then you should really talk about making low cost options available to people. And of course, I was also trying to look up, there was one American case, I can't remember the name of it, where a lady went to the court and said, there is an arbitration clause in my contract, I don't have the money to afford the fees of the institution, and therefore it's a denial of justice, please, you the court, take up my case. I think in that particular case, the court rejected it and said, for whatever reasons, maybe on the facts of the case that you can afford it something, but those cases are a matter of reality, and maybe we need to think about some sort of a solution to those cases where absolutely impecunious clients who are on the verge of insolvency are not denied justice just because they've chosen arbitration. But I think the number of those exceptions that you'll have to deal with if you reduce the overall cost of litigation on arbitration will be far, far fewer, because people genuinely want to get some resolution. So if for that they need to spend a little money, they're willing to spend that amount of money. But having said all of that, right, I mean, there is always going to be a spectrum. And I think it goes back to one point which I really hope everyone, including the biggest law firms in the country, take note of, which is when you enter into the contract, you don't know the value of the dispute. I have had so many situations where, well, I'll give you one example. There was a shareholder dispute between a promoter and the other promoters. The company had raised some VC funding. It was at some 700 crore valuation, the company. Now, because it dealt with the valuation of shares and allocation of shares, etc., SIAC clause, we went in, filing fee already, whatever, 3,000, 5,000 Singapore dollars. And then on top of it, because they're looking at a 700 crore figure in terms of the value of the dispute, you can imagine what the ad valorem fees for that was. Our person was looking at a dispute for about 2.5% of the shares that he was looking at. And even in that, the dispute between the other promoters and him was a very small margin. So suddenly, because the law firm which drafted that SHA had put in an SIAC clause, they have contracted him out of justice delivery, right? And that is, I think, where we really need to start relooking at whether the arbitration clauses that we're drafting today is doing justice to our clients. We are actively advocating what we call a tiered arbitration clause, which is essentially saying, in the event a dispute arises, there is a choice of 2 or 3 institutions that you have, each of a different tier, so that at the time the dispute arises, the parties choose, because then you know what is the value, what's the complexity, whether you need the fee schedule of an ICC, whether you're okay with the fee schedule of an ODR institution. That, I think, is where we really need to move to, because the one-size-fits-all approach, both in terms of fees, in terms of institutions, has done disservice to litigants today.
The vote of thanks then, since there are no more questions. I just actually had a comment to make as well. I was just rereading Gayatri Balasamy, and I think none of the parts of the ratio that you can discern from the judgment mention anything about the doctrine of merger. So in the context of the problems that you run into in international commercial arbitration. So when you modify, and that becomes an order of the court under CPC, that is not merged with the antecedent arbitral award, right? So then when you haven't merged both things, you cannot sort of enforce it in foreign jurisdictions where your assets are located, right? So this is the majority part of the judgment where they dismiss this concern that there is no need for us to pronounce on this doctrine of merger. It's not relevant. So there's no authoritative pronouncement on that. So I wonder if it really sort of applies to international arbitration also. Now that the judgment has come, maybe someone will clarify, some bench at a future point in time, as to the scope of its application. But my assessment right now is that this judgment is only applicable to the extent of domestic arbitrations in India. If you have a SIAC-seated arbitration, you're seeking to enforce that SIAC award in India, I think you'll run into all sorts of problems. And I know how to get out of that rigmarole, right? So,
I know you're moving to the vote of thanks, but can you do this?
Yeah.
Look at the New York Convention.
Right.
You have an arbitral award between 2 Indian parties. Does the New York Convention apply? The fact is it does.
Oh.
Because the moment, so it is not based on the nationality of the parties.
Right.
It is based on if you have an arbitral award which is made in India, but you seek to enforce it somewhere else, the New York Convention automatically applies. So this distinction between national, international, foreign, domestic, etc., is not really relevant from the New York Convention's point of view. You have an arbitral award. It's currency that is printed. That currency can be transported across national borders. And that's what the majority missed. organized. I think there is some reference to it in Justice Vishwanathan's judgment, where he says that the New York Convention aspect is an important thing that can't be glossed over, but the majority just doesn't deal with it at all. And the issue is this, I mean, I think people don't recognize that an arbitral award between two domestic parties can in fact be enforced under the New York Convention.
Yeah, correct. I think that makes more sense. And I think like as I move on to the vote of thanks as well, like I'll tell a personal anecdote from a legal services clinic. So like the clients that approach us regularly, so they ask us what the remedy is available to us, right? And generally, like as students, we are not supposed to give legal aid. So what we tell them is that before we connect you to a lawyer, we just want to understand from your end as to what do you want from this? Do you want to like litigate this, or do you want to settle this with the other party in any manner? But the moment we say settle, or the moment we say anything about ADR, they say that we cannot afford arbitration, therefore the only option is to go to courts. So my point is to equate arbitration with ADR and to render all the other forms of ADR into the underbelly of ADR. It's, I think, doing a disservice to legal aid at large, right? Because like none of the clients that we have received so far have been successfully been referred to arbitration because of the cost barriers inherent to the practice, right? So I think it's really great the work Vikas sir is doing, and I think like if it's democratized to even student legal aid clinics, I think we'll have a broader dragnet and to sort of include clients which are otherwise not being able to afford that. On that note, let me thank you all first for bearing with us and in this rather chilly room. And then a heartfelt thanks to all our panelists and moderators, Pramod sir, Vikas sir, Anand sir, Dr. Jaya and Apoorvi ma'am. And I think like what this panel discussion has done at the bare minimum is introduced clarity to the discourse. Because it's not about whether the judgment is right or wrong. The fundamental question is what the judgment actually said. And I think the panelists have clarified as to what it actually says now, so that we can then sort of be clear in our heads that, okay, like this is the part of the discourse that we're going to take away from this room. So, and again, so thank you so much for this enlightening discourse, and I'm really grateful to you as students and members of the audience. And I'd also like to thank Manipal Law School for mooting this Bangalore Legal Forum in the first place, especially Sarsu ma'am, Amulya ma'am, and everybody else involved. Yeah. And obviously to the Bangalore International Centre for providing us a venue, and everybody who is involved behind the curtain, whose efforts are not unnoticed, including the logistics, etc. And finally, I don't want to be pompous, but also to our team at the Legal Services Clinic, who I'm the sole member of because exams are going on. So maybe a pat on the back. But yeah, maybe on that note, we can all sort of join us in applauding the panelists again and sort of